Welcome to Clause 8, the #1 podcast on intellectual property, trusted by top in-house counsel, judges, and policymakers worldwide. Hosted by Eli Mazour, we bring you in-depth conversations with the personality shaping IP. Brought to you by TradeSpace, where ideas take flight.
Today, we're lucky to be joined by Corey Salsberg, Global Head of IP at Novartis, one of the world's largest pharmaceutical companies. Thank you for joining.
Yeah, my pleasure. Thanks for having me.
So I first heard of Corey through actually somebody else on the other side of the IP debates. And he said that Corey is actually somebody he respects who's on the other side. And I'm not going to name names because I don't want to get him or you in trouble. But I just wanted to start, I guess, by asking you, when you hear something like that, and what comes to mind? And I guess, why do people have this impression of you?
Well, the first thing that comes to mind is who that person is. And I know the answer, but I won't say. It's a mutual respect. Look, I mean, at the end of the day, IP is a really important area of not just law, but of economics, society. It's been the foundation of our country and really economic growth and innovation all over the world for hundreds of years. And even though there are disagreements between, in certain debates, certain areas of IP, I happen to believe that there's a lot more common ground than people think. I also just believe in having dialogue and debate, even with people who disagree with everything that you believe. I mean, we don't need to get into, the political situation in the world today, including the United States in general. But I think the more we speak to each other, even where we disagree, the more we realize that we have more in common than people realize. So that's always how I approach every discussion. I also think there's strength, frankly, to our own positions substantively when we try to understand what the other side has to say and try to process it, think about it. Is there something there that I'm not thinking about? Because it makes me appreciate more where, what the issues may be and strengthens our own arguments sometimes too.
So we'll be talking a lot about IP policy today, but you actually started your legal career in IP litigation. Can you tell us the story of how you ended up in IP policy? Yeah,
sure. I mean, I won't go back too far, not to my birth or anything like that, but no, I mean, I was one of those people that, that went to law school not intending to necessarily even go to law school, or once I made that decision, it was more, I was just in college. I'm working for a year. I worked for the New York City government actually for a year, doing some really interesting stuff, more in the media side with the Parks Department of New York City. And then I realized, I looked at my paycheck and I said, this isn't really going to be a long-term arrangement that was going to work for me. And I'm not really sure what I want to do. So the idea of going back to school again for another 3 years sounded good. So from there, I went to law school with interest really in the intersection of technology and society more than anything else. Never really planned to go necessarily into law. I wasn't sure what I wanted to do. Was originally going to do some corporate law. Then the tech bubble burst. This was back in the late 90s, early 2000s. Tech bubble burst. It affected life sciences as well. I had an interest in life sciences and ended up kind of falling into litigation and ended up really liking it. I did IP litigation, mostly patent cases for two different main firms for almost a decade. Moved in-house in 2010.
And was most of the IP litigation pharmaceutical or? No,
actually. So that's another interesting thing. I mean, I have no business being here in this chair talking to you about any of this, really. I mean, I'm one of those stories that, one of those people with a story that, not planned and lots of different turns, unexpected turns. But I enjoyed patent litigation, doing a lot of medical devices. I represented at one point Heinz ketchup, with the caps to the ketchup bottles, rotors from laboratories, and then eventually got involved with contact lens cases. And that's what brought me into the healthcare field, really, because Novartis at that time had a big big contact lens company. We were involved at my outside firm at the time in those cases. So went in-house and continued to do litigation in-house. But then started getting involved in the American Invents Act, the policy discussions around that, and really enjoyed it. I had, as I just briefly mentioned, a short stint in city government. I was actually I'm not even a scientist by formal training. Love technology. I think I have a good sense of technology and figured out how to use it in litigation, but I'm not a technical background. So I was really more of an American history, American government, American studies was my major. So all of that kind of came together when more and more policy issues came up. Found it really interesting. Moved over to Europe, to Switzerland, at our company's headquarters, and spent a lot of time there, expanding into policy that was not U.S. based while still doing the U.S. And from there, it grew and grew and grew, and eventually moved back to D.C. and got further into the policy side.
So I'm thinking about the timing, because it's interesting. You started doing, I guess, litigation about the same time when the narrative about patent trolls kind of heated up, which led to the AIA. I guess, what was your experience actually doing litigation during that time, and then then being involved in hearing about all these problems? How did your experience match with what you were hearing?
Yeah, I mean, in the biopharma side, the patent troll issues were never an issue. We really didn't have those kinds of cases. For one thing, as you know, in the U.S., you have these unique litigation systems for life sciences, at least for brand to generic. So you have the Hatch-Waxman system. The BPCIA on the biologic side was brand new around the same time that law came. I think 2010, 2011 was enacted. The biologics law, which created this kind of parallel system, a little bit different than Hatch-Waxman, but also different from the general litigation system. And, there are anecdotally a handful of so-called patent trolls where there's, a patent owner with some vague invention that would go after a pharma company, maybe for a website or something. But really, that was not where we were in terms of that side of patent litigation at all. The reason why this became an issue for us was more that in trying to address those issues, the other industries that did have, complaints about what was going on were trying to change the entire patent litigation system altogether, right? In ways that would make it more burdensome for legitimate patent owners to assert their patent rights, make it more expensive, make it more burdensome to file and write your pleadings and your complaints. So all of that was kind of how to your opening point about someone from another industry, who sometimes we don't see eye to eye. What I find is that it's rare for us to truly not see eye to eye on issues that matter to either one of our two industries. If we're talking about high tech versus biopharma, it's really more that the goals and the needs that we have as different industries aren't the same. And if you're not, if you just want what you want, you're not thinking about how it, inadvertently impacts other industries, that's where we tend to get the tensions, which is why I always say, well, thinking back to my law school days of mediation, how do you get to yes? There's that famous book, Getting to Yes. And one of my favorite stories from there is, the two kids fighting about an orange, right? Yeah. They both want the orange and they can't agree, and, they don't want to split it down the middle. And then the mediator comes in and figures out that one of them actually wants the skin and one of them wants the fruit. So if you actually just took the time to figure that out, it would have been easy to make a deal. And that's the way I see a lot of these issues with high tech. Because we don't support true patent trolls. That is not something that our industry has ever supported. Our issues are more that, look, if you want to address those problems, do it in a way that doesn't harm legitimate patent owners. So that's kind of how I came into a lot of that particular debate. I also think, by the way, just really quickly, substantively, the Supreme Court stepped in after that, and with a bunch of different cases that ended up, we think, solving a lot of those patent troll issues, frankly. Pleading standards under this Twombly case did get actually a little bit more, you had to be more particular. There were some other changes as well. So it's an issue that we thought was resolved in a lot of other ways. I understand the tech industry still has concerns. It's not really our set of issues, as long as they don't toy with the overall litigation system and make it hard to legitimately enforce patents.
I guess one of the ways the patent system was reined in by the Supreme Court that I guess has impacted the pharma industry is on 101 patent eligibility. Yeah. And the timing of the interview is pretty lucky because you actually testified on that subject this week. So we're recording on October 10th. It's been 13 years, I guess, since those series of cases kind of started at the hearing, you mentioned that you testified 6 years ago, I guess in 2019, when they had those 3 days of hearing about patent eligibility. I think it was something like 45 witnesses, and they were making a big push. But you said since then, since, they put in all that effort into highlighting the huge problem about what has been done with patent eligibility, things have gone from bad to worse. I guess, can you tell us about that? And I guess why has that happened?
Yeah, I mean, so quick background for people who don't really know the whole issue. I mean, the U.S. has always had a very, very broad, historically, very, very broad set of patent eligibility laws under what's now codified in Section 101 of the Patent Act. This, of course, is what defines what types of inventions in general, right? Not particular patents, what types of inventions can be subject to the patent system in general, right? So there are certain things that are outside there. I mean, a work of art, right? That's copyright. That's not patent. So, of course, you need to have some kind of explanation. And since the beginning of this country, there have been certain categories that are patent eligible, processes and manufacturers, machines, and compositions of matter. These have all been in since the 1790s, things that are patent eligible. And there have always been these kind of exceptions that have been implied by the Supreme Court law in the early days of the country, which they called products of nature, natural laws, and abstract ideas, right? The thing is, these were historically defined as exactly what they sound like, common sense things. So product of nature, and this was talked about at the hearing, right? An apple on a tree, one of the senators mentioned this, that's a product of nature. So someone can't find an apple and say, I'm going to patent that. It's not eligible for the patent system because it already exists in nature. Fine. The law of gravity, this is in the case law, by the way, a new plant in the wild, a new mineral in the earth, the law of gravity equals MC squared. Those are the four kind of archetypal examples that the Supreme Court used to give for the implicit judicial exceptions. And what happened in this trilogy of cases, Alice Corp, Myriad, and Mayo in 2011 through 2014, I think they were, they basically really changed what these cover. So rather than a law of nature being like gravity, suddenly a diagnostic method of correlating different levels of a drug in the blood with a condition in the body was considered a law of nature in a patent claim. It's a huge step, right, from a natural truism to that. On the gene space, we went from a mineral in the earth to a gene that's extracted through chemical isolation out of the genome, right, to make a new chemical entity, which is a composition of matter, by the way, by definition. Scientifically, you take a gene out of a genome, it's a new composition of matter. But they said isolated genes are not eligible. And then on the abstract idea side, which is not really our set of issues, they said a lot of software under the Alice Corp case is not eligible. So that was 2019. That's what I was referring to about we were concerned then. What's happened since then, to your question, is we were worried in 2019 that the test itself that the Supreme Court had is so vague and broad the way it's applied. We don't have to get into the details here, but that it would keep spreading to new subject matter. So it's bad enough that the Supreme Court has now moved from these universal constants into things that are actually, we would consider forms of technology. But if it's going to continue to morph and the target is going to continue to move and expand into more and more subject matter that's no longer eligible for the patent system, this is going to start cutting into the core of the cutting edge fields that matter to the future of medicine. And that is really what the case I talked about, which is a case that was just heard earlier this week by the Federal Circuit, is a case that involves cultured host cells, genetically engineered in a laboratory, that include DNA, recombinant DNA, which if you're not from that field, what that means by definition is that it's combined from two different sources that don't exist in nature. In this case, it has to be, this claim itself specified, two different species spliced together into a genome that doesn't exist in nature, put into a cell that doesn't exist in nature, and it's useful in creating the viral vectors that deliver genes to patients who lack them in gene therapy. So now we're talking about a huge shift, in other words, from even isolated genes, which you can debate, whether or not those should be eligible. But now we're not talking about genes. We're talking about clear applications of genetic material where everyone, including the defendant in that case, agreed does not exist in nature. And what that means is, and let me just say one more thing about that. In the reasoning of that case, the district court judge said, well, the way I read the law is if you take components of nature and you combine them into something that doesn't exist in nature, that's not enough to be patent eligible. You actually have to change the underlying components of nature every time to even be eligible for the patent system. If you think about that, that's all science, all technology, everything. The Supreme Court has said this itself. Everything is based on nature in some way or another. If you create a new chemical, you're taking, the elements from the periodic table. You're not changing the underlying the atoms of nature, even if you're creating a totally new material. So this is an untenable position. And yet it's at the federal circuit and we don't know what's going to happen. So that's why we need Congress to make clear enough is enough. We need clear standards. We need to decide what we want to be patent eligible. We need to decide what we don't. Make it clear so that people know where to invest.
This is a somewhat cynical view, I guess, a bit about how we got where we did with the course and patent eligibility. But one view goes, well, Supreme Court justices have said as much. Scalia has said, patent law is a very complicated area of law. They heard about how bad patents are, and they just, find all these ways to rein them in. And when I hear that, I'm like, all right, well, they're going to do that, but they're not going to mess with innovation in the medical field. They're not going to mess with the innovation that helps save lives and finds cures. And then I hear about like Myriad. Okay, they made their point, but they're not going to move the goalposts. And you're saying it keeps getting worse. And I guess, why do you think that is? Like, what is the disconnect that, the law, if you look at the 101, it doesn't require them to do that. And yet they always kind of find a way to...
I think a couple of things. I think the Myriad case, clearly, if you look at the plaintiffs, right, the ACLU was involved. I think that the way I read that case is that there was something in particular about the human genome and human genes that raised societal concerns that they seized upon. I don't agree that was a fair treatment. I think, when you're talking about isolated genes, it's not the same as the genes in the human genome. No company, to my knowledge, is interested in or even tried to, to patent the genes as they exist in the body. The idea was that isolating them is what you use to create a diagnostic. In the case of the Myriad, the BRCA1, BRCA2 genes. Putting that aside, whether you agree or not with what the Supreme Court did, one of the points I always make in this area is I actually think unusually, almost uniquely, the Supreme Court, if you read that case, and I'd encourage, the whole IP community to go back and read it, the court is incredibly careful to keep its holding very narrow. The last paragraph of the entire decision says, we merely hold that genes and the information they encode are not eligible on account of being isolated from the genome. To say we merely hold, and then before that, by the way, they back up and they say, it's important to note what's not implicated by this case. And they talk about applications of genes, methods of analyzing genes, all that.
It's almost like they recognize the risk of it being too sweet.
Absolutely.
Yeah.
That is, they rarely, think about it. How many opinions can you name that say, let us go on for pages about what we're not holding?
Yeah.
That's not what a court does. They talk about what they are holding, or they don't say anything because, you're supposed to figure out what
it's not what somebody with power usually does in DC, right?
Exactly. So they're saying we want to be very clear about what's not implicated here. To me, I read that as they were being careful for exactly the reasons you said. And yet the problem is not with the Supreme Court at this point. You asked, how did we get here? The problem is that I don't think they intended to create a test that would keep morphing. But the lower courts and the patent office have struggled with the test, this Mayo two-step test. And as they have applied it, they've applied it in ways that just keeps growing. That is not what the Supreme Court, I don't think, ever intended.
But why are they applying it in that way?
Because, I think that it's vague. Not intentionally maybe, but what it says, of course, is what is the claim directed to? Well, think about that. What does that mean? And the court started saying, I don't know what that means. Judges are not technical experts in most cases. The Federal Circuit itself says this all the time. Half of the Federal Circuit doesn't even have a science background. So they think their job is to go find one of these ineligible concepts somewhere in a claim, which includes nature. And as the Supreme Court says, there's always nature embedded in a patent claim because it's scientific or technological. The problem is they've then interpreted, they've found this stuff, they've crossed it out, what we call the Sharpie test, right? They've like scribbled out the natural law and then have started holding, well, let's look what's left, dissect the claims into old and new, which violates the Diamond versus Deere case from 1980. I think it is 1981, I think. And then they, if you're just looking at what's left, then you're ignoring what most innovation is, which is applying, sometimes old thoughts to something new. That's progress. That's innovation too. Yeah. So I think it's just the nature of the test was not well thought out. That's why we're where we are.
The main topic of the hearing was the PERA, which is the Patent Eligibility Restoration Act, which is supposed to, I guess, fix some of these problems. And that was, I think, the version was introduced in 2022. Last Congress, it didn't even get past the committee. This Congress, I guess Senator Tillis, who's the chairman of the subcommittee on IP, is very interested, but I'm not sure if there's really strong interest elsewhere. I guess why, with all the issues that you mentioned, why is there no why is there like a lack of traction? Or disagree, I guess.
I think it's a fair question. I mean, I think, look, a few things. First of all, patent law in general, unfortunately, is not well understood by most Americans or by most members of Congress. It is in the Constitution, as you know, your podcast, Clause 8, right? I mean, it is a reference, right? I mean, it's I assume, constitutional.
I was going to thank you for giving a plug at the hearing to it.
Oh, right. Yeah, every time. No, I mean, this is a constitutionally based system. Our founders realized how important it was. But I think it's been taken, it has been doing the hard work in the background of making it, this country the leader that it has been in innovation and economically for so long. But it just has worked, right? So I think most people, just like many things, if something is working for hundreds of years, you take it for granted and you don't necessarily focus on it. When it starts to break down, it's a surprise, I think, to most people to even learn that this is something that is constitutionally based, to learn how important it is. And then, frankly, these issues are complex to try to understand, and I think there's also an appeal to the idea that things that truly exist in nature, of course, those shouldn't be, eligible for patenting. Although the Constitution does say discoveries, no one really quite knows what that means. And the court, I think, has never truly interpreted the term separate from invention, right? What's a discovery? Because it says both. I think there's an underappreciation for just how important Section 101 is. It is truly what tells innovators in any patent-driven industry. It is the opening gateway that says these are the things that are going to be incentivizable or investable, through the patent system, and everything else is not. So depending on how broadly or narrowly you define that, that is where the investment goes. I don't think there's enough of appreciation for that. I don't think there's enough members of Congress who focus on IP. I would, one of the long-term goal in my view for any innovator should be to try to encourage more education and more people who champion IP in Congress, regardless of politics. That's where I stand on that.
So I guess from a practical standpoint, can you give us like a company like Novartis, like how does it impact the decisions that it makes because of where 101 is today?
Well, I mean, fortunately, as I've said in my testimony, I mean, we have not, the pharma industry has not yet been nearly as affected by 101 restrictions as the diagnostics industry has. And you have to separate those. There are some pharma companies who have diagnostics businesses. We used to years ago. We don't now. It's not, I mean, I can't say it's because of 101. There's lots of other factors. But we are truly starting to get worried now with this case, the one I mentioned, this Regenix Bio case that was just heard last week that I talked about in my testimony. This is an area where if it continues this way, that's why I gave this example of, the reasoning is more concerning even than the individual case. The reasoning, components of nature put together, if that's no longer eligible, that's everything that biotech and the new frontiers of medicine do, because we're trying to actually replace natural things and get away in some ways from non-natural chemicals into the body, right? Because if you can fix things using biology and genes and just make things right the way they're supposed to be, then you reduce side effects, you get more efficacy, you're actually fixing the core of the problem instead of treating symptoms. So that is, we're concerned with the trajectory, and that's why I think, why we're concerned. In terms of your comments, why is no one paying attention? Is this really going to move? I mean, I can't predict where this will go. I certainly see this as a really important long-term issue, and one that we have to make sure we keep reiterating how important this is, and how people need to be aware, members of Congress need to be aware where this is going in the courts, and ideally stop it before it actually goes there. That's how you avoid problems. Because if we have to fix it after the fact, and we've started to lose ground on important areas of innovation and to competition with other countries, then we're not in a good spot. So that's kind of our message. We understand that there's a lot of uphill battles to get this passed now. We hope it does pass now. Senator Tillis at the hearing said that he wanted to make it a priority. We're all in favor of that. But even if it doesn't come to pass now, let's keep it moving, because it matters.
I want to take a moment to thank my sponsor, TraceSpace. TraceSpace is an intuitive, AI-powered IP management platform that spans the life cycle from idea disclosure to portfolio strategy and commercialization. TraceSpace uses enterprise-grade AI to cut administrative workloads by 40%. So you mentioned this, but I guess the boogeyman or the straw man, depending on the argument of the bill, is human genes. Like, people are going to be able to own your body by getting patents on these genes, and they've made an effort to make it clear, no, that's not the bill's not going to cover it, but the same arguments are made. Yeah. So I guess how do you get over that hump, or just that's not the hump to get over, I guess? No,
I think that, first of all, to be realistic, there's two things to get over. One of them is not our set of issues at all. So there's the software side of the debate, which is not, that's the high tech area. Yeah. I mean, it's part of this bill, and we're supportive of the bill as a whole, but I'm not expert enough in the, in the way the software issues have been addressed, but that's another hurdle, I think, that is being worked through on just in terms of, will this legislation go? Because it tries correctly to fix Section 101 altogether, because we cannot have separate patent systems for every field of technology. That's not a good outcome in our view. So that's all good. On the gene stuff, this is simply, in my opinion, a matter of education. This bill, as I said myself at the hearing, I wish it had a little more time to explain it, but that's not how hearings always go. We believe, and it's our reading.
That's why we do this.
Yeah, right. It's our reading of PERA that it actually very clearly codifies Myriad, of all things. That's the irony, right? It is saying, okay, unlike past versions of it, where there were some who still think, just like China, Europe, Japan, Korea, and I can name a few others, currently and have always allowed patents on isolated genes, even if they're exactly the same as what exists in nature, because they're useful when you actually isolate them. We don't do that. The old versions of PERA tried to do that. This version of PERA tried to answer those concerns and say, okay, let's codify Myriad. We will say isolated genes, just like Myriad, are not eligible. But again, just like Myriad, applications of those genes, applying them to medicine, science, gene therapy, diagnoses, these are eligible. And modifications of genes, whether it's cDNA, which the case in Myriad explicitly found eligible, or modifications of the order of genes, like in this Regenexx Bio case, because they splice together genes from two different species, so that's a modification. The Supreme Court itself said those are eligible. So we believe that this version of PERA is actually just codifying the status quo. And you might say, well, if it's just codifying the status quo, then why is there any problem with just the status quo? And the answer is what I explained, that the concern is not for us, putting diagnostics aside, it's not that today is unworkable. It's that it is starting to head into the direction where it is becoming unworkable. So we need to freeze the spread by codifying Myriad, and that should answer the critics' concerns. that, about patenting genes, even though, again, I pointed out yesterday also at the hearing, why do we have these concerns? Every other country seems to have figured out how to have patents on these things and not have a sudden halt of science and innovation the way critics claim would happen here. It doesn't make any sense what they're saying. We have real world evidence that every other country can figure this out. So why can't we?
That first problem that you mentioned with satisfying, I guess, the big tech interests.
Yeah.
I've heard of two conflicting theories last time around. One was that the reason PERA came about is that big tech and big pharma made the secret deal to cut out the small inventors. The other conflicting theory that I heard from, I guess, the big tech side as well, big pharma just really needs to work with us, and then we'll find a way to kind of resolve their issues. I guess, which one is, can you, I guess, tell us, I guess, your perspective of where you think the pharmaceutical companies are? I know there's probably diversity of views.
Yeah.
And I guess, why don't you just make the big tech happy, give them what they want, and they could give you a carve out for the types of inventions that you want.
So I can answer your question somewhat. I can't comment on conspiracy theories about. I'll just tell you, my view of this is, and I'm not speaking for the industry, but I can share with you, which the industry's perspective on this is what I already said. We have one patent system. We have one patent system that's been there since, 1789, the ratification of the Constitution, unchanged, right? It has worked. We have one patent system for all technologies globally. WIPO, has one patent system. The TRIPS agreement in the WTO is set up to be technology neutral. And in fact, it actually has a provision, Article 27.1 of TRIPS, that expressly says that you cannot discriminate against fields of technology in the grant or enjoyment of patent rights. There's a reason for this. It's because technology, number one, should be treated equally. Number two, the bounds of different fields of technology always evolve. And if you think about today, AI becoming part of pharma, healthcare moving into tech and software driven. It's all one big giant technology ecosystem in some ways. So putting aside all the, whatever politics may or may not be behind the scenes of this, we believe strongly that we should have a single patent system with a single eligibility statute, even though it may, have certain subject matter exclusions like PERA does. Those are very specific for a reason, right? It shouldn't say just broadly, this kind of technology is okay and this kind is not, because we want a broad, just like the founders wanted, a broad statute that encourages broad innovation, broad thinking, broad investment.
So you're thinking about the whole system as a whole, I guess, in the long term. You mentioned, obviously, Senator Tillis, he's retiring. He said he wants to get it done before he retires. But I guess another big reveal this hearing was that now Senator Schiff is the ranking member on the Democrat side. I think, at least my read of it was that maybe he's in that role because he's a freshman member of the Senate. He didn't have much choice. He did ask a question about, the impact on pricing from strengthening patent rights. I guess maybe you can get your sense. What is the impact of now Schiff taking over Coons' role? And then also, what else needs to happen for this actually to get over the finish line?
No, I think you're right. Look, we have a shortage of IP champions in Congress, both in the House and the Senate. I don't know the exact number. It depends on how you define an IP champion, but I'd say it's probably no more than a dozen who are even, very educated on all the IP issues. There are some that are very copyright strong, but especially on the patent things, there's not that many members of Congress who have made this a real priority of theirs. Senator Tillis is certainly one. Senator Coons on the Democratic side is one. All the sponsors in this bill, right? Senator Hirono has been a strong champion of IP rights. And it's not to say that others are against strong IP rights. I think it's just not been there. Every senator can't be a champion of everything, right? So they have certain areas. I believe the IP community across the board needs to work on having more, because whatever your views are on IP issues, unless you're completely against the IP system, which I hope no one is, then we ought to have, support for, I think, more people who at least understand the importance of the system and the different ways that it works for different industries and wants to solve problems. I think that's really important. There was a lot of really good talk about the bipartisan nature of IP at this hearing, which I love to see. I can't predict what will happen. I do think, of course, Senator Tillis retiring because he's been such a champion I'm not retiring entire, but from the Senate, so, not running again. That is definitely a loss and something that I hope will be replaced. I hope Senator Schiff, I was actually very, optimistic that Senator Schiff, he was incredibly thoughtful questions. He and his staff seem to really understand, the issues here, ask good questions. I don't know, and it's not for me to say, where he is on this bill, but I hope that he'll be someone who's, at least willing to listen to all sides and understand how things impact. And that was really our my goal yesterday was to explain how this stuff impacts us in real life. And I have actually found that when you try to boil it down to that level and sometimes, drop just the talking points and actually have a real conversation, which is what I always hope to do, in terms of engaging with policy, that you can get to, some level of common understanding. So that's what we need to do more of, I think. And we'll see what happens. I mean, there's, after Tillis is no longer there'll be a gap that needs to be filled on the Republican side if we're going to have an IP subcommittee. And what happens between, Coons or Schiff or someone else is hard to say. I mean, that's, not my area really of expertise or I don't think anyone knows, right? Because it's a couple of years from now. So
as I was preparing for this interview, I saw that in law school, I think you wrote a law review article called Resurrecting the Woolly Mammoth.
Yeah.
So I want to ask you to make a prediction. I haven't read the article. What's more likely, that woolly mammoth will be resurrected in our lifetime or PERA gets past this Congress?
That's a tough one because both are plausible. I mean, not in this Congress. I'd say, look, I mean, I don't think anybody thinks it's going to be an easy road to get PERA passed in this Congress. And some of that, to be fair, is not because of PERA, right? There are so many other things going on in Congress, other priorities, rightly so. I mean, as important as IP issues are, and they are critical, I think, in a lot of ways, we have other critical things, right? There's wars going on in the world. There are budgets to balance. There are all kinds of concerns that, I'm not really qualified to get into professionally on these other substantive issues. But as an American citizen, right? I mean, we have a country to run, and we all understand that. I think all companies, all industries, all Americans hopefully understand how busy Congress is. So we have to think about it in that context, in addition to the context of PERA itself. The woolly mammoth stuff, I mean, that is fascinating stuff. I will just really quick, just to link these together. One of the cases that came after Myriad was the Roslin Institute case at the Federal Circuit, where they found Dolly the sheep, the cloned sheep, to not be patent eligible, even though completely created by human beings, because it wasn't different enough from a natural sheep, they said, even though clones are not the same as, which is why they
So setback for that.
Right, setback for that field. But, anyway, it's, hard to say. Two different sets of issues. But the mammoth may be coming. And the good news there is if you like meat, some of the plans might be to make mammoth burgers, as I wrote about in that article. So,
everyone should check it out.
Right.
So as you mentioned, 101, I guess, hasn't been the most pressing issues for pharmaceutical companies dealing in policy. Last administration, we saw, I guess, there's been a narrative that actually patents are the cause of high drug prices. Mm-hmm. And then we saw kind of an effort to get, the administration to put forth policies to kind of rein in patents in service of that. And there's a lot of things at the USPTO, all these proposals about thickheads, making it harder to get cons, raising fees, even proposals for margin rights. I guess, can you just share your experience of navigating, I guess, the previous 4 years? Yeah.
So this is where, once again, Mark Twain comes through every time. And he's and this community, your audience knows this, but Mark Twain has like some of the best patent quotes ever, right? He's got the one about the crab, like, a country without good patent laws is like a crab that can only move sideways or backwards. But he also, and by the way, the reason, just really quick aside, the reason for that, which is really interesting, he was a patent owner himself. He has a patent on bra straps, a a patent on a board game, and a patent on, there's one other one. I forgot exactly what it was. Oh, a self-adhesive scrapbook.
Okay.
And actually, he made more money on that self-adhesive scrapbook than any of the books that he actually wrote as an author. Just a little side note of trivia. But one of my other favorite quotes of his, which is not patent specific, is, a lie can travel halfway around the world while the truth is getting its shoes on. And that is exactly what has happened, unfortunately, with this narrative that it's all the patent system. That's why drug pricing is wrong in America. Drug pricing, which I'm not an expert on, I obviously know some of it because it's in our industry, but it's a very complicated thing. It's been written about that today with, PBMs, middlemen, our healthcare system, all of that.
We've seen the pharma ads.
Yeah. The system, right. Pricing is pricing. Yeah. The only thing that patents do is give you an exclusivity period. They don't tell you what the price, therefore, of a drug should be during that period. So that's one way to slice that. The problem we're getting is, you have these activist groups that are perfectly, let me just be clear. I think having activist groups on any issue is good. Having different voices, expressing their opinions, that's all great. The problem is that if they're not doing it truthfully based on accurate data that they can back up, that they're willing to share and publish and debate, then we're not really having a policy debate. We're having an ideology debate. And that is not helpful no matter what your views. I don't think it's helpful no matter what your views or your interests are. It's not the right way to do things. And that is what has happened. So the patent thickets, the claim for years from these groups has been that there's 30 to 50 years of exclusivity on every drug and that there's hundreds of patents on every drug. The real data that the USPTO under the last administration and this one both have confirmed, which is consistent with other studies that came from independent academics, is that the average number of patents on a drug, an Orange Book listed drug for small molecules, the big studies show it's 3 to 5, and the average in the PTO study from last year was 8.6 patents, which is a tiny number of patents, right, compared to the thousands or hundreds of thousands on high technology, things like that. This patent office said the same. Thickets are not a problem compared, they're very rare in the pharmaceutical field. In terms of the real thing that people should be asking, though, it's not the numbers of patents, right? The real question ought to be, how long is a drug actually exclusive? Because the link between drug pricing and patents, it is true that after a drug comes off patent, generics enter the market and then the prices come down because there's more competition. That's how the system is supposed to work. That's the public bargain, right? You get the patent for a limited term, which is what the Constitution says. And then the competition comes in. Everyone's free to use. And the question ought to be, how long are pharmaceuticals getting an unduly long period? Fair question, right? What is the period of a patent? 20 years. What is the period that Congress put in place under the Hatch-Waxman Act that small molecules as a minimum are supposed to get? 14 years, the bill says, Hatch-Waxman Act. That's the patent term extension system. It's supposed to aim to give you a minimum of 14. Okay, so what is the average period that drugs actually get before generics come in the market? It's 13 years. Less than what even Congress says in Hatch-Waxman, far less than the 20 years you're supposed to get. Even biologics, which are not under the Hatch-Waxman system, but the newer BPCIA, those, the averages are slightly higher, 15, 16 years right now, but that's because that system is so new. So we're not getting anywhere near where we're supposed to. And these groups are still out there saying it's 50 years before a drug goes generic.
I guess the point I want to mention is that there's been all these groups out there for a long time. Yeah. And I guess they seem like fringe views, but then you actually had all these policy proposals that were kind of implementing their ideas. Were you concerned that some of these could actually get pushed through, or you knew like, hey, there's going to be a rocky period, but we're going to...
No, very concerned, because this is why I go back to Mark Twain, right? Because it's that quote, right, about the lies spreading halfway around the world. Because what happens is these groups spend a lot of time and effort making these flashy, nice looking, official looking reports. They send them all around Capitol Hill. They talk about it. They get invited by, some politicians to come testify about these reports. They publish them in journals, and the mainstream media that never questions the accuracy of the data. And, frankly, drug pricing is a populist and important issue. that resonates politically. So it's convenient, I think, is my theory, right? It's convenient for people to also be using it to their advantage to, for whether it's political, whether it's, for some other special interest. So these things take on their own legs and they get legs, they spread, and it's very hard to walk back a false narrative. And no matter what the false narrative is, once it spreads, I mean, you guys know, look at anything on the internet today. Yeah. Once something spreads, it's very hard to pull it back. And so we are concerned. This has led to, there's a bill now, a bill about patent thickets, right? Limiting the number of patents you can assert. A lot of legislation like that could go somewhere based on these false narratives.
That's interesting to hear because, as somewhat an outsider perspective, I thought, well, maybe these are just theatrical moves that the administration is taking, and they know none of these policies come to pass. But it seems like you had real concerns about them going through that. So I guess you breathed a sigh of relief, maybe, that you got through those 4 years and none of these kind of came to pass. And then this administration starts, and there's these FTC and DOJ listening sessions on lowering drug prices. I guess, can you give your take about how those have gone, and I guess where we are, and what are your concerns? Or
absolutely, and that pretty much underscores the point. So you are correct that, and we were very happy to see that the last administration, despite all of the pressure on the patent system, I think ultimately nothing really bad happened, which we're happy to see, and we'd like to think that's because, as I mentioned, the Patent Office itself under the last administration did a study. Senator Tillis had actually requested that study, looked at these sources of information that were not only anecdotally driving these debates, but were cited in a lot of if you look at what I call the beauty sheets that accompany draft legislation or bills that are introduced, they're frequently citing these groups and their data as a reason why we need to have these patent thicket bills and these other bills like that. But to their credit, even under the last administration, who was critical, I think, of these issues and sometimes seemed to be following those narratives, that patent office under the last administration did that study in 2024 in summer last year and found that the average number was 8.6 patents in 13 point something years. In the study. So it proved the point that data is not correct. This administration, the patent office has been good. But again, because, false narratives are difficult to correct, we were continuing to see a lot of these narratives pop up in this FTC DOJ listening sessions under this administration. That is concerning. We certainly hope that this administration will be data driven on that issue. I mean, this FTC and others looking at this. I will say the Patent Office itself, in that was a three-party three agency process, right? These listening sessions were Commerce, DOJ, and FTC, all three of them. And the Patent Office, especially in the last session, they spoke. They were very clear that they believe that patents need to be there, that multiple patents are not unusual, and they stood up for the system. So we're hoping that that'll lead to a dialogue and that the right answer will be based on the actual evidence and the actual data here. But it would be not accurate to say that we're not concerned. We are concerned, because they continue. We see it still. There's still legislation pending on these issues. There's still, these listening sessions. We don't know what will come of that. And we just think, once again, we firmly believe that on true evidence, facts, and data, we win these debates because that's just how the facts come out. So we hope that someone pays attention to them, and hopefully then that resolves the issue.
But what do you think what the plan was when they organized these listening sessions? What was their goal? Were they truly listening sessions, or?
Well, I mean, look, listening sessions are rarely just completely objective without any pre-baked views of something. I mean, it's politics is politics, right? So there's some political, I can't comment on exactly what was motivating these, but any government proceeding is probably whoever's running it, and whoever's in office may have views. To be fair, I mean, agree, and we as an industry agree, that drug pricing is a serious problem that needs fixing. We just don't agree, I think, on what the causes are and what the solutions are. So we're hopeful that these kinds of processes are the opportunity to have those open dialogues, to be able to, everyone gets to put forward their data and facts, and we hope that our elected officials will take those and apply them to good policy.
So I want to briefly touch, I guess, another maybe bipartisan narrative that has survived administrations is this narrative about, we briefly talked about it before the recording, about margin rights, that, government is spending all this money, and then all these companies are making these drugs and making all this money, now you're hearing, well, you're hearing a different version of this now, where before, I guess they just wanted to seize those rights in the last administration. Now they want a cut of those profits. I'm interested, I guess, in you sharing your perspective about that piece. Yeah.
All right. So 3 different issues there. And that's where I think it gets a little confusing. 3 completely separate facets of Bayh-Dole. Okay. Bayh-Dole Act, as you know, was there in 1980. It was enacted to make sure, or actually really to try to fix this problem of having government funded, federally funded research sitting on the shelves. Something like 95% of it was untouched. Fixed it by saying, okay, if a private sector entity comes in and invests in commercializing any federally funded research, they can keep the patents. The last administration and some members of Congress, prior to that, had been asking for the expansion of what's called Marchant rights. Marchant rights were there to make sure, we certainly, the way we read the statute and have always understood it, it was there to make sure that those who get federal funding actually go through with doing everything they can to make sure the research does get commercialized. And if they fail to do that, Marchant rights were there so that the government can come in and actually make it happen. In other words, make a license to a private sector company happen. That's the main gist of Marchant. The last administration to deal with drug pricing proposed a set of draft guidelines, which still have not been rescinded. That is concerning, by the way, to say, in addition to marching in for the reasons that something's not actually been made, the practical application of the technology hasn't been made by actually licensing it, we also want to authorize, for the first time in history of any administration, Republican or Democrat, that the government could come in if we don't like the price of a downstream product if it has been commercialized. That's not in the statute. If you read the statute carefully, it's clear that Congress didn't intend it to be in the statute. That's what the last administration wanted to do. We were very concerned about that from a systemic innovation ecosystem perspective because it would chill federal funding. But to be clear, this is another case of wrong facts, wrong data to solve a problem, an alleged problem, because the biopharma industry in particular has very, very few, almost no drugs that are actually federally funded, the drugs themselves. The data shows that about 8% of all FDA approved drugs from the last really 30 years, whatever it is, had any federal funding. 8%. Only about 1.4% of all drugs had enough federal funding of the core inventions that they'd even be a target for Marchant rights, because Marchant only pertains to the actual patent that received federal funding. So even if you agreed with the concept of policy-wise and legally that Congress can march in on the basis of downstream product, it wouldn't have worked, because that's not how it works. The funding goes to basic science, really important work that universities do. I want to stress that, but not the work that ends up in the patent.
Yeah.
Then
I think it's
and then I'll get to the other two, but go ahead.
This whole argument is over 1.4%. Potentially over
on the Marchant side, yeah,
over 1.4%.
One drug out of 100, if that.
Yeah.
And even then, there's going to be other patents that the government would not access. Yeah. What's happening now, separate from the fact that draft guidance, which was terrible guidance and we don't think consistent with the statute, I hope that still gets rescinded. I hope it's just that they haven't gotten around to it, because it's really inconsistent with this administration.
Actually, Laura Peter, former deputy director, she also mentioned that. That's not being rescinded.
It should be rescinded. I don't see it as consistent with anything this administration wants to do. That's a good thing. It should go. The proposals on Bayh-Dole that have since come out in this administration are something different. There's 2 of them. One is this idea that there's been some public letters to universities, in that whole context of this administration not liking certain things about universities and what they're doing, has sent letters saying that you need to make sure you're complying with the Bayh-Dole Act. They're not talking about March-in. They're talking about if there are inventions that have not been made use of commercially, like if you haven't actually taken steps to license them, or if you didn't timely disclose an invention to the government, which the law requires you to do. This is actually all part of the law. And the question there is, I mean, hopefully, if these kinds of oversights do happen, and they do happen from time to time, and if they've been done unintentionally, our view, and because we don't take federal funding very often. I mean, big companies aren't really the contractors. The contractors are universities. The contractors are small startup companies, those two. We, though, are sometimes the licensees of that technology. The earlier stage version, parts of technology, we in-license that in order for us to build on it and develop our drugs. So if we have a patent like that and there's been some formality that wasn't complied with, timely disclosure wasn't complied with, as long as it was inadvertent, we hope that there'll be a way to fix it and address it, because we don't want to shut down the incentive to keep commercializing federally funded research. I don't read this administration as trying to do that. They will actually want to commercialize research and see the value of it. And in fact, that's what leads to the third bucket, which is a totally different issue, which is the Secretary of Commerce mentioned a couple of times that there's potentially or an idea of taking a cut of the royalties that get paid by the commercial developers back to the university to license those usually basic research related patents. And that is, whether that's concerning or not depends, right? It depends on how that's implemented. Is that going to be an additional royalty on top of what's already paid? Is it going to be a cut of what the university already gets? Is it going to come on companies? We don't know the answers to that. And the question will be, what effect will that have on the commercialization of important research? Because I think no one wants that. We don't want to chill the commercialization of important federally funded work.
It'd be interesting to have a study on that, because my understanding, at least, when these university licenses, whatever, they license for the purpose of it getting commercialized, not for the purpose of making a lot of money off it. At least that's my, I guess my...
Well, when they make money, to be clear, I mean, I'm not at a university, so I can't speak for them, but my understanding is when a university does make money, and sometimes they make a lot of money in royalties from a very good selling product, but that money goes back into the university.
Right.
They're not for profits by themselves, right? They're not buying cars with this. They're
goes back
putting it back into
the purpose of why I guess they got their federal research funding in the first place.
Right.
I guess, where you sit now, thinking, I guess we're almost a year into this administration, or I guess maybe not almost, depends who you talk to. It's 3/4 of a year, but I guess what concerns you, and I guess what concerns you maybe going forward about the patent policy
in this administration?
Yeah.
Well, let me start with the good, because there's a lot of it. Yeah. I mean, I think this administration is one of the strongest, if not the strongest, pro-patent administration we've seen. I mean, and there's lots of evidence of that. Both Acting Director Stewart and so far Director Squires. I mean, the first day in office, as you know, Director Squires very publicly signed patents and granted patents in fields that are, arguably in the 101 space, right? Yeah. Some AI patents and some diagnostics patents, which, I mean, you have to look case by case, I would say, so I can't comment
this
on
is a medical device.
Yeah. And I can't, I'm not suggesting that those patents shouldn't have been granted or should have. It's just that he said himself, right? This is a symbolic gesture to point out that they believe these things should be eligible and are eligible. Yeah. Great. So that's a pro-patent stance, in my opinion, and not just pro-patent, but pro-innovation and the right thing. This administration has been very strong in renouncing the last administration's position on the TRIPS waiver, which was a terrible decision, in clarifying and saying publicly at WIPO that the U.S. is not going to sign this genetic resource treaty that messes up, really confuses the patent system with something called the Nagoya Protocol on genetic resources and associated traditional knowledge, which is also a pro-patent thing. You can criticize or not, depending on your view on different parts of the IP community on the PTAB stuff, but clearly this administration is interested in addressing some concerns that have been raised about overuse of that process. So I think this administration has been very, very pro-IP. So I want to start there before I talk about concerns.
Yeah.
On concerns, I think it probably goes without saying for this community and your audience, but probably our biggest concern is the talk that came out in the Wall Street Journal article a few weeks ago and continues, about a tax on patents, whatever that looks like. If that were to come to pass, a lot depends on the details and what that would look like. But if basically it becomes excessively more expensive to secure and maintain patents, that's not a good thing for innovation, and it's especially not a good thing probably for smaller inventors. But even for bigger inventors, right? We want to be able to patent all of the great inventions and innovations that come out of our company. We don't want to have to say no because the budget, gets to be prohibitive. So, and from a policy perspective, in my view, if you want to encourage patent filing and you want to encourage innovation, you want to encourage, competitiveness on the innovation front, which I think this administration does, it has said this, right? That you want to basically remove barriers to patenting, not add new ones. So we're hopeful that discussion, that dialogue with the administration, my understanding from remarks that were publicly made, by Acting Director Stewart when she was in place before John Squires was confirmed, she said that, that there would be a process for this. We hope that continues, rulemaking process, so we can actually chime in, if it proceeds at all, I should say that we'd want to be able to make sure that we have the opportunity to express our views on things, and hopefully it's a dialogue. So we'll see.
Yeah, I guess Director Stewart said, very early, nothing definite, don't believe what you're reading. I guess beyond that, have you heard anything else to reassure you that, I guess?
It's been rather quiet. There have been some articles about it. There's been, lots of writing about it. I think it's obviously up to the administration whether they want to pursue something like this. I think that we are open-minded to hear any proposals. I really believe a lot depends on the details here. Sometimes, you can't read too much into an article, but there may be more to it than that. I guess we would just have to really need to see what the details are before we can really fully comment on how good or bad or neutral we are on the particular proposal.
Yeah, I guess to me, it just, it seems odd that I guess it'd be I don't know if you agree, but it'd be just a corporate tax in a different form, but only on companies that obtain patents. I don't know.
Right. Well, I mean, that is a question, right? Will this be actually a corporate tax, like a wealth tax kind of thing, or will it be, more like a fee, the maintenance fee, the filing fee, an adjustment there? And if it's the latter, the question is it a reasonable adjustment of fee based on legitimate PTO activity, or is it being used to fund other things? And then we have to think about, that there's
and that's because in the law it actually says the fees should cover. They shouldn't be raising money for other parts of the government.
Correct. Under the current statute, the PTO's fee setting authority should be linked to its operating budget, but that of course could be changed by Congress. The other big question I think here, a fair question that everyone's asking, is however it's structured, how would you value a patent, right? What's the value of a patent the day it issues? A lot of times, especially in our industry, the patent issues on a compound, for example, you may be years or decades away from when you've actually launched a drug. So how do you know what that's worth? What happens if the patent gets invalidated? Does that mean that it was never worth anything? Do we get our money back?
Yeah.
Because I'll tell you, like countries in Europe that have wealth taxes, right? They charge you every year on the value of your overall assets as an individual, for example. If suddenly you've got a lot of stocks, let's say, and the next year the stock market crashes, you don't get your money back from that prior year because the value of your assets went down. So these are questions, and we don't know the answer. And again, we're hopeful the administration will be transparent and open to public comment and adjustments and all of that. If it does proceed with this at all, which, we'll see.
So it's fair to say, but it seems you're positive, but there's a few concerns.
I'd say it's not that I'm necessarily positive, but that we don't want to, jump the gun and be hysterical about things that are not that have not been disclosed publicly and had a chance to discuss. And we always try to give lawmakers the benefit of the doubt if they have an idea. I mean, again, I go back to the very first thing you asked me, right? My view of the world is we should always be discussing, we should be sharing perspectives, and we should try to reach common ground where we can. And so that's why I'm maybe, I don't know if I'd call it optimism, but just kind of, hesitant to prejudge too much.
I meant
I got you.
IP policy overall, but I guess I want to ask, you've been doing this for a while. You said that since the AIA was in discussion. So I want to get maybe some of your advice. Let's say somebody is just stepping into an IP policy role at a pharmaceutical company. Maybe they were doing litigation there. Mm-hmm. What advice would you give them about being effective, or about even just figuring out all these different things that are going on, all the different people involved? Like, where do you start, and how do you spend your day, I guess, day-to-day basis, I guess?
I mean, there's lots of things I could say. I mean, I think it's really important, first of all, I mean, if you want to do policy effectively, you really do have to understand the subject matter. There's a lot of people, who say they want to do policy of this kind or that kind, no matter what the field. And yes, there's certainly a skill set and an art to, speaking to whether it's lawmakers or stakeholders in the system. And I think being well-spoken, being able to write well, being a strong advocate, those are all the also important skills. But if you don't know what you're talking about, then I think that's a real issue. So that's number one. I mean, that's why, to me, the litigation background is really helpful in both fronts, right? I mean, as a litigator for a decade, even though I'm not a patent prosecutor, I know patent law so well, right? I mean, I learned patent law in terms of the litigation side.
Did you say that?
I think I do. Maybe I'm wrong. But I also, to my point though, as a litigator, right, what's the job of a litigator, right? And especially in a complex field like patent litigation, it's to take really difficult legal and technological concepts and to translate them into advocacy points to know your audience. So if it's a bench trial, you need to convince usually a non-technical judge of not only understanding the basis for what you're saying, but why, they should actually agree with you. And for a jury, it's the same idea, but often a different level, because no matter how brilliant a jury may or may not be in a given case, they certainly, unless they're all lawyers, which you probably, get them out of voir dire, they are not going to be well versed in the law. So you need to understand your audience, I guess, is something I'd say, and you need to be able to speak to that audience and meet them where they are. That's a huge, huge skill in policy. That's what makes, I think, people effective. And I think it's also important to be honest and genuine. That's what we try to do.
How about just navigating Capitol Hill and the agencies, and, you have limited, I guess, bandwidth to do that, and to keep up with all these people. Any advice about that?
I think it's working well with, depending where you are and what your role is, it's working well with lots of different stakeholders, including, if you're at a company like mine, working very, very closely and in collaboration with public affairs experts, with, your business to make sure that you're understanding what their goals are, your scientists to make sure, I testified 2 years ago in the Senate and last year in the House on AI issues, right? I didn't grow up as an AI expert, so I had to spend time talking to our AI scientists and the patent attorneys that deal with our AI, intersections to really make sure that I understood. So you really need to be someone who is, I think, out there in your own company networking and understanding, all the different facets. And then externally, you need to work with your partners, whether it's trade associations, alliance groups, members of Congress and their staff. Staff is huge. Understand that just like just like a CEO in a company, CEOs do really important leadership work, but they've got a whole team of people who are doing actually the groundwork and giving their advice. So if you want to persuade a member of Congress, you're not going to do it with 3 talking points, meeting with the elevator speech. You're going to do it by spending the time with staff to really make them understand the issue. So that is, another one, the courts. You probably know I'm the current Federal Circuit Bar Association president. I've gotten, very active with our court system because, as a litigator, but also I feel that's an important, even though they don't decide policy in that way.
Well, I assume you wanted to get away from that. That's why you went to policy.
Actually, it's fine. I wanted to get away from e-discovery and billing my time by the hour, but I love the courts. I mean, I love the judiciary is obviously an equal, and critical branch of government in any democracy, including ours. I have nothing but respect for what the judiciary does. We don't always agree with their opinions or even, their trends. And that's fair. But with the work they do, it does not get celebrated enough. And that's a stakeholder that I think a lot of policy people forget. We're not asking, courts to decide cases in our favor and decide policy in that way, because that's not what judges do. But judges will tell you themselves, they want to understand what the policy implications are of even their individual decisions. That's why we have amicus briefs, right? That's a really important role that judges, again, they're not overtly policy people, but these are, I try to think of the world of stakeholders in policy as being as broad as you can think of, even the general public. In fact, not even, that's the ultimate stakeholder.
Yeah.
Every one of these other people is just a representative of ultimately what's best for our society as a whole. So we don't forget about them either. And that's how I try to view things. And that's what I'd say. But really the communication, the ability to speak, the ability to sit here and have a conversation like this. I mean, this is where I think and to be fair, I want to be very clear. It's not like I, was born with all of this stuff and just like anything, right? You have to work on this. Like, I think the first time I spoke publicly on this stuff, when I first started, I think I was terrified. I forgot exactly what panel it was, but I was probably reading my notes, with my head in there. And the more you do it, the better you get at it, like anything else. So I encourage more companies in all industries to actually invest in it, because I think in the IP space, because there's not enough of us out there who understand what we're doing, but also have the willingness and the ability to communicate it to everyone else. And I think that's a real asset, no matter what your views are on an issue. It's so important. IP is so important to the world in so many ways. We need more champions, more advocates.
Well, Corey, that's a great moment to end on. And I definitely agree. I think it's a bigger presence of people who know about IP would definitely be helpful in DC. So, Corey, thank you so much for joining Close 8.
My pleasure. Thanks for having me.